Another liberty right, which is not well known to people, is the rule that there may be no impairment of the obligations of contracts. What that means is that the government just can't go out and change contracts which were lawful when they were entered into. So that's one that people don't think about a lot, but think about this. If you had let's say a candidate for president, and he said, if you elect me, I will take all your MasterCard, Visa, and other credit card debt and reduce it all to zero. After all, look how much they charge in interest and late fees and over-limit fees and that sort of thing. Well, you can't do it. About the only exception to that rule comes in bankruptcy circumstances, where sometimes in order to treat all the creditors with some degree of consideration, that the bankruptcy court has the power to invalidate contracts so as to benefit as many creditors as possible. But beyond that, the government normally cannot impair these obligations of contracts. Good to know. Now, there are some liberty rights which we really that really make a huge difference, in our daily lives. Some of those came from England, and they go like this. In the United States, per our Constitution, when there is a trial, it is almost always required to be open to the public. That is, public trials are part of our constitutional liberty rights. Jury trials in criminal cases are part of our liberty rights. Even jury trials in many civil cases are part of our liberty rights. So the framers were big on the notion of having a fair trial. Now, one of the rights regarding trial is not the strongest right in the world, and that's called the right of a speedy trial. Well, what happens there? What's speedy? If it's too speedy, you might not get justice. If it takes too long, you might not get justice. So that's given to a lot of interpretation. In terms of protections of the defendant, there are some that are so critical that thank goodness that they're specified. For example, the notion of no unreasonable search or seizure, that people have a right to be protected in their homes and person, that they get that protection. You have to have probable cause of some type in order to seize someone, to seize evidence, that sort of thing. That's a very critical right. Another one that is critical is the whole notion of the right to confront your accuser in a criminal case. In some countries, you don't have that right. In fact, in some countries, you don't have a right to a jury trial, or you may be tried by judges, or you may not even be able to contest or test the evidence. In some countries, you're tried by a judge or group of judges, or a magistrate that just looks at the paperwork. We don't operate that way here, thanks to our Constitution. So these many liberty rights that affect the rights of the individual in the face of government are so important in keeping us free. Now, in terms of some liberty rights, you won't find them specified in the Constitution. Let me give you an example. You've heard of the right of privacy. The case of Roe versus Wade, privacy rights with respect to your body, and so on and so forth. The thing about it is the word privacy isn't even in the Constitution. So how can you sit there and declare that you have a right when it isn't specified? Well, the thing is, that was a concern to some degree at the Constitutional Convention, and to some degree it was dealt with in the Bill of Rights. The Ninth Amendment to the Constitution states that the rights that are enumerated in the Constitution are not considered to be the only rights that you have. The idea that people are endowed with some natural rights. We're not sure what the scope of the Ninth Amendment is, but it does mean that you're not limited purely to the rights that are specified. I think one of the major liberty rights has to do with the effect of statutory law. There is a liberty right that prohibits what are called ex post facto laws. For example, let's say that they pass a law January 1 of 2019 that says it's illegal to smoke cigars. For cigar smokers, that would be a tragedy. But let's say such a law was passed. Well, you could not prosecute someone for smoking cigars in 2018. In other words, the rule against ex post facto laws in many instances, not 100%, but in many instances, prevents from retroactive enforcement of laws. The idea is that if the government could do that, they could criminalize anybody at any time. They could say, basically, we've decided that this was bad, and you should have known it before this statute was enacted, and that's just the way it goes. So the rule against ex post facto laws is critically important, and it's not entirely limited to criminal law, but it does have its points. How do you get a liberty right determined when it's not specified in the Constitution? Well, that'll take us to the early 1800s. The first election involving political parties was the election of 1800. The three major candidates were John Adams, the incumbent president, Thomas Jefferson, the incumbent vice president, and Aaron Burr. Now, basically the way it worked back then, you did not have a ticket election. In other words, basically what would happen is you would have the person with the most electoral votes would be president. The runner-up, the person with the second most electoral votes, would be vice president. In the election of 1800, there were political parties. There was, basically the Federalists and then the Jeffersonians, if you will. President John Adams, he didn't get a second term. He came in third. But the funny part is, Aaron Burr and Thomas Jefferson tied with the electoral votes, and what ended up happening was, when you have a tie, it goes into the House of Representatives. So at any rate, the point being that the House of Representatives elects the president in the event that there's a tie in the Electoral College. Of course, Jefferson ended up getting the vote in the House of Representatives and became president. Aaron Burr, became vice president. Now, on with the story. John Adams, as the story goes, was very upset that he lost a second term, and he believed it was because of the manipulation and chicanery of Thomas Jefferson, aided by James Madison, who was close to Jefferson. As the story goes, that in those days, almost every federal job in the bureaucracy, for example, in other jobs, they were granted by the president. And so basically what happened was a number of appointments were made before Jefferson took office that affected his ability to choose officials that he wanted. This was somewhat aided by the Congress, but basically the story goes that John Adams stayed up till midnight on his last day of office to appoint as many people as possible so Jefferson would be deprived of that. One person that he appointed to be a justice of the peace, if you will, was a man named Marbury. And Marbury was appointed, but he had to get a commission signed by the Secretary of State. Jefferson's Secretary of State was Madison. Jefferson instructed Madison not to sign commissions with respect to a certain number of these appointed officials, one of whom was Marbury. Marbury sued to get his commission, and the case became known as Marbury versus Madison. And in this case, the Supreme Court of the United States, by way of Justice John Marshall, the Chief Justice, issued an opinion that essentially said that all statutes by the Congress can be subjected to review by the Supreme Court to determine their constitutionality. And in this particular case, it involved the Judiciary Act of 1789. And in essence saying that the Supreme Court of the United States would be the final word on what the meaning of the Constitution was by using this power. So, as a result, there have been interpretations of the Constitution by the Supreme Court that creates rights that aren't necessarily specified as such in the Constitution. Privacy is one of those. Although privacy is not specifically stated in the Constitution, there are certainly indications that it was intended to some level. Freedom from unreasonable search, freedom from unreasonable seizure, freedom from having to quarter soldiers in your home. These sorts of things, they made it possible for the Supreme Court to conclude that there was a right of privacy with respect to your person, and in a number of instances have supported challenges to government authority to be able to interfere with your body, for example. So again, you have issues of interpretation. This notion, this Marbury versus Madison notion, that the Supreme Court of the United States can exercise this power is controversial. The idea is you've got two camps now. You've got the Marbury versus Madison camp, and you've got basically the traditionalist camp that says, look, if it's not stated in the Constitution, that means the legislature should deal with it, okay, not the Supreme Court. Otherwise, you risk having the Supreme Court as a super legislature. The contrary argument is, look, in the United States, we have evolved. We have evolved socially. We've evolved technologically. And so many times the Supreme Court is called upon to interpret our Constitution in light of modern problems, modern challenges, and that sort of thing. Because let's face it, that technology happens. It changes things. You think about the time of the Constitutional Convention of 1787. They had no television. They had no iPhones. They had no any kind of phone. They had no telegraph. They didn't have any motor vehicles at that time. No aircraft. They had no computers. All of the things now that we have, all of this technology creates legal challenges. In other words, think about it. The whole notion of hacking. I mean, hacking, there was no such crime as hacking at the time of the Constitutional Convention. There was no kind of offense. You know, there was no offense for publishing someone's nude photos on the internet because there was no internet. So the fact of the matter is the Supreme Court of the United States is called upon sometimes to apply this law by now ancient people to our modern country. And so as a result, it has created change in our law. And the question is, what do we do? Is that the way we continue to operate? Where does the legislative power end and the Supreme Court's authority to legislate, if you will, by interpretation, where does that go? So this is a constant problem that we have to face. But the fact of the matter is that, you know, the Supreme Court remains under Marbury versus Madison the final meaning of the Constitution. What can be done in these situations? Let's say you have a set of circumstances that is just unacceptable, where one of the branches of government perhaps has too much power, this sort of thing, or has taken it upon themselves to give themselves power. Well, there's various ways, but the surest way is to amend the Constitution, you see. And so you think about the amendments and what they have meant. You know, now we have direct election of our senators. That's an amendment. We have the right to vote granted, you know, to all citizens, regardless of their race, gender, you know, national origin, as long as they're citizens. You see, that was by amendment. The 18-year-old vote, by amendment. The elimination of a poll tax in federal elections, by amendment. The end of slavery, by amendment. Yeah, so much has been accomplished that way. But in reality, over 200 years have gone by, and we only have like 26 amendments. And one of them was canceled. That is the amendment against alcoholic beverages. So in essence, really 25. And what happens is that some of those are structural to make sure things work better, okay? Like having a ticket run for president instead of having, you know, a president from one party and a vice president from another party trying to undermine the president, that sort of thing. So those are structural types of changes. Some are liberty rights changes. The Civil War, of course, led to the 13th, 14th, and 15th Amendment, which made certain liberty rights clearly given to the people of former status as slaves, dealt with equal protection under the law. And so, at any rate, the amendment process is one way of dealing with an excess, but it's not easy. That you have to go through, you either have to get a large percentage of the legislatures, or the legislature, or a large percentage of the states to get an amendment passed. Now, the other way you could do it is you could have a whole new constitutional convention. You could have a convention to make changes. But, you know, who's going to show up at that? What kind of wild party is that going to be? I don't think we're going to have that happen anytime soon. So the Constitution, it sets up our governmental structure. It establishes the authority of the federal government versus the state governments. And it sets forth numerous liberty rights that provide us protection. Now, for those of you who are watching this video, who are my introduction to law students, you have been given a list of liberty rights. You have been given a list of the powers granted to the federal government by the Constitution. You need to look those over carefully, because when you come back to school, any questions you have about the Constitution, I'll take them at that time. But you're going to have a test on it, and you better know some stuff. Okay, we're gonna take a break at this point.